Hello everyone, I'm Leonard French, your favorite copyright attorney, and boy do I have a doozy for you today. You may have watched one or two of my videos on the BitTorrent file sharing cases that have been filed by the thousands over the past 7 or 8 years. Well, we have here a declaration under oath from a defense attorney who claims to have found some inconsistencies in these cases. Some inconsistencies like fake people, copied signatures, and maybe fake corporations. We'll see. I'll let you form an opinion for yourself, and we'll go from there. And so you know who we're talking about, this is attorney Christopher Lynch, patent attorney and partner in Spokane, Washington in Lee and Hayes. He has litigated numerous intellectual property matters and has argued in federal courts in Washington, Oregon, Idaho, California, Utah, and DC. He is a practice group leader at Lee and Hayes for trademark, copyright, and licensing, and has spent his entire career working in intellectual property law. He is also a professor teaching intellectual property law for 20 years, and he is also a representative to the Ninth Circuit Judicial Conference and other very nice affiliations here. So as you're considering what we're about to read, this is the defense attorney it comes from. So this is the declaration of J. Christopher Lynch in the U.S. District Court for the Western District of Washington in various cases here that appear to be from Strike 3 Holdings as a plaintiff and Venice PI as a plaintiff. J. Christopher Lynch declares under penalty of perjury as follows. I have represented defendants in other BitTorrent cases filed by David Allen Lowe's law firm in this district, although not in these Venice PI cases. Both the court's order to show cause, docket 32, and plaintiff's response, docket 33, cite me by name. This prompts this response to clarify facts I have discovered. I respectfully request that this court entertain this declaration, and I would testify in court if requested to do so. I submit this declaration in response to the declarations of Daniel Arheit, docket 37, David Lowe, docket 38, and Benjamin Perino, docket 39, in the lead case. Mr. Perino's declaration at paragraphs 4 to 18 provides a detailed work background that does not include U.S. Copyright Group, for which Mr. Perino submitted numerous declarations in other districts. Mr. Arheit's declaration at paragraph 7 to 17 provides a detailed work background that seems to contradict his claimed work history in a declaration in the District of Columbia. Mr. Lowe's declaration provides an explanation that no declarations regarding Crystal Bay Corporation or Darren M. Griffin have been filed in this district, but they have been filed in this district. I provide significant detail below to support these three principal points as completely as possible. I apologize to the court for the density of the information and the length of this document, but the subject matter warrants the detail. All documents cited in this declaration are PACER records. I have not attached paper copies, but I reference to the district case number and ECF number of the cited pleading or exhibit. This declaration includes inserted graphics which are copies of signatures from some cited PACER accounts. I have faithfully reproduced these signatures to the best of my staff members' ability, but the originals remain in PACER for review. I have used PACER search techniques to thoroughly investigate BitTorrent litigation, particularly non-pornography cases. There are thousands of cases in numerous but not all districts over the past 9 years. I have discovered certain facts that are inconsistent with the declarations of Mr. Perino, Arheit, and Lowe filed in these cases. These inconsistencies seem relevant to the administration of justice and compel me to make this declaration. I have concluded that a fictitious declarant, Darren M. Griffin, claiming a relationship to Crystal Bay Corporation of South Dakota in its technical department, was used to obtain subpoenas in hundreds of cases, including numerous cases in this district. The declarations in this case of Mr. Perino, Arheit, and Lowe do not claim any relationship to Darren M. Griffin. However, there is a direct connection between Darren M. Griffin and declarants Perino, Arheit, and Lowe. My declaration documents those connections. Mr. Arheit and Mr. Perino state differing work histories in differing declarations. In 2010, starting in the District of Columbia, non-pornography BitTorrent movie lawsuits began being filed. The majority include a declaration of Mr. Perino, who filed declarations between 2010 and 2012 in cases against over 10,000 individuals. Mr. Perino claimed a relationship to U.S. Copyright Group. Mr. Perino's declarations were filed with declarations of Patrick Atty, claiming a relationship to Gardelay Limited. In those cases, Mr. Arheit filed at least one declaration that was identical to Mr. Atty's, including the personal background. These 2010 through 2012 declarations are inconsistent with Mr. Perino's current declaration and Mr. Arheit's current declaration. In New Image versus John Doe's 1 to 6,500 in the District of Columbia, Mr. Arheit's 2011 declaration claims more technical experience than Mr. Arheit's 2018 declaration would seem to make possible. In 2011, he said he was Director of Data Services for Gardelay, a company incorporated in England and Wales. Gardelay is a provider of online piracy services. Before my employment with Gardelay, I held various software development positions and consultant positions at companies that developed software technologies. I have approximately 10 years of experience related to the protocols, technical architecture, and operation of the Internet. At Gardelay, I am the head of the department that carries out evidence collection and provides litigation support services. I work closely with our development team to create credible techniques to scan for, detect, and download copies of copyrighted material on multiple network protocols for use by copyright owners. Mr. Perino's declaration in that same New Image case in 2011 claims a position at the U.S. Copyright Group that is not disclosed in his 2018 declaration's recitation of relevant work history. His 2011 declaration says he's one of 4 managers at the U.S. Copyright Group, a private company dedicated to anti-piracy efforts in the motion picture industry. In order to assist plaintiff in combating infringement on peer-to-peer networks, the USCG retained Gardelay Limited, a company incorporated in England and Wales, which provides anti-piracy and copyright protection services. In this New Image case, Mr. Arheit's declaration is 18 paragraphs in length, and Mr. Perino's is 13 paragraphs. Mr. Perino filed identical 13-paragraph declarations in similar cases filed from 2010 through 2012, usually filed with a declaration of a Patrick Atty instead of Mr. Arheit. In Mr. Arheit's declaration, he claims to be a 35-year-old native German in Karlsruhe, Germany, attending primary school till 1993, secondary school till 2001, and then 2003, serving in the military till 2004, and then in 2005 completing 2 semesters of business informatics. He attends vocational training from September 2006 to June 2008. He's had a number of internships, temporary staff till 2001, fitness company till 2002, a temp in 2003, an intern in 2005, and an intern in 2006, an inside sales representative in 2009, and been working at Gardelay since December 2009, which would be approximately 10 years, except they're saying here that he has 10 years of experience in 2011. So someone has lied to the court back in 2011 about their experience as an expert witness investigating piracy cases worth many thousands of dollars. The earliest example of declarations from Mr. Perino and Mr. Atty is Act Nunte versus John Doe's 1 to 2094. Mr. Perino's declaration is identical to the same one in the New Image case above. Mr. Atty's declaration is identical to Mr. Arheit's New Image declaration above, including the 10 years experience paragraph, the credible techniques paragraph. In Act Nunte, Nunte, Mr. Achache claims, I'm Director of Data Services for Gardelay, a company incorporated in England and Wales. Gardelay is a provider of online services for the motion picture industry. Before my employment with Gardelay, I held various software developer and consultant positions. I have approximately 10 years experience. Mr. Lynch then says he has searched for additional common witnesses and other commonalities and found what appear to be photocopied signatures in the declarations of Mr. Perino and Mr. Achache. For example, Mr. Achache's declaration in West Bay 1 versus John Doe's 1 to 2000, aka Maverick Entertainment Group versus John Doe's 1 to 1000 in the District of Columbia, filed 2010, appears to have a photocopied dateline and signature from another document in Mr. Achache's Act Nunte declaration cited above. Mr. Perino's declarations in these two cases also appear to have a photocopied dateline and signature, and you can take a look for yourself. They appear to be handwritten signatures that are photocopied. Attorney Lynch cites other examples of photocopied signatures by docket number. We won't go over every single one of them. Mr. Perino claimed to work for U.S. Copyright Group in each of the 2010 and 11 cases where Mr. Achache and Mr. Arheit claimed to work for Gardelay. Then, in March 2012, Mr. Perino's declaration's opening paragraph changed, eliminating any current or future reference to the U.S. Copyright Group as copied verbatim below. I am manager for Gardelay Limited, a company incorporated in England and Wales. Gardelay is a provider of online anti-piracy services for the motion picture industry. I submit this declaration in support of plaintiff's motion for leave to take discovery and for internet service providers to disclose identifying information of unknown defendants. It may be that Shirokov versus U.S. Copyright Group and Gardelay, a federal lawsuit alleging fraud in copyright litigation, influenced this change. During 2010 and 11, Gardelay and U.S. Copyright Group became defendants in a lawsuit alleging litigation abuse. The case was filed in 2010 against Act Nunte, U.S. Copyright Group, Gardelay Limited, and the lawyers Nicholas Kurtz, Thomas Dunlop, and Dunlop, Grubb, and Weaver. Gardelay moved to dismiss, claiming that Gardelay was not subject to personal jurisdiction given its purported location in England and Wales. The plaintiff opposed, submitting documents about Gardelay's location, systems, and relationships to Mr. Perino and U.S. Copyright Group. Gardelay moved to strike those documents as inconsistent with its Rule 12 motion. On March 27, 2012, Judge O'Toole dismissed Gardelay for lack of personal jurisdiction. Following the dismissal of Gardelay, Mr. Lynch reports that it does not appear from Pacer that Gardelay was overt about its role in BitTorrent cases in the U.S. court system. No new plaintiffs used declarations of Mr. Perino, Achache, or Arheit. Gardelay was not mentioned in newly filed cases. From what I can discern, Gardelay's pornography cases apparently continued to claim IPP Limited as the purported investigator. From what I can discern, Gardelay's non-pornography cases in 2012 moved primarily to claiming Crystal Bay Corporation as the purported investigator. Malibu Media and Tobias Pfizer, Gardelay's pornography cases. Certain currently filed pornography cases in this district claim that German company IPP conducted the investigation using IPP employee Tobias Pfizer. Mr. Pfizer has consistently claimed to be an employee of IPP. Mr. Perino's present declaration claims Mr. Pfizer is an employee of Gardelay as well as IPP, and he refers to document 39, paragraph 20. Gardelay has employed, among others, the following individuals: Daniel Arheit and Tobias Pfizer. Each of these individuals performed their duties in Germany. They never performed any of their duties for Gardelay in the state of Washington. I also personally met each of them, says Mr. Perino. Other than Mr. Pfizer's opening paragraph and references to IPP instead of Gardelay, Mr. Pfizer's declaration in the pornography case Digital Content v. Doe's in the District of Maryland is identical to Mr. Arheit's and Mr. Achache's 18-paragraph declaration discussed above. I am employed by IPP Limited, a company incorporated in Hamburg, Germany. IPP is a provider of online anti-piracy services for proprietary digital content. I have studied software development and have approximately 5 years experience related to the protocols, technical architecture, and operation of the internet. At IPP, I am head of the department that carries out evidence collection and provides litigation support services. I work closely with our development team to create credible techniques to scan for, detect, and download copies of copyrighted material on multiple network protocols for use by copyright owners. The remaining paragraphs of Mr. Pfizer's declaration are identical to the declarations of Mr. Arheit and Mr. Achache cited above, other than the substitutions of IPP for Gardelay. Mr. Pfizer has submitted numerous declarations for other pornography cases, including the Malibu Media cases. Mr. Lowe's response seems to speak of Malibu Media similarly to Prenda as a bad actor. He claims Malibu Media apparently uses similar forensic technology to identify BitTorrent infringers, albeit obtained from different data providers and licensees than plaintiff uses in these cases. But Tobias Pfizer is a direct connection, claiming to work for IPP, with Mr. Perino claiming he also works for Gardelay. Note also the metadata in Mr. Lowe's response. Almost all of Mr. Lowe's BitTorrent pleadings on Pacer using Chrome show 1 in the tab at the top and 2 in the header of the document what appears to be his firm's document code. For example, the response docket number 33 shows a number beginning with INIP. Presumably this is a code for Interior IP LLP, an undisclosed entity connected to Gardelay, and codes for the plaintiff, the matter number, the pleading, and the document title. But note the metadata for the exhibit to Mr. Lowe's declaration, docket 38, where the INIP code is not used, a code including Malibu is used. Despite the response document at docket 33, there is a direct connection between the non-pornography plaintiffs and the pornography plaintiffs. It is in the metadata. Here are screen captures showing the INIP metadata from docket 33 and the Malibu metadata from docket 38. He's referring to these here. This right here with INIP at the beginning and this right here with Malibu at the end. As to the non-pornography cases, after the Shirokov personal jurisdiction ruling dismissing Gardelay no longer filed declarations directly for new plaintiffs. Declarations using copied paragraphs from Mr. Perino's and Mr. Achache's declaration were then seen from 1. Exhibitor USA, 2. Copyright Defenders Inc., 3. IP Squared Technologies, and 4. Crystal Bay Corporation, although there could be others. Crystal Bay Corporation was the most prolific. Mesut Tarhan at Excubitor USA. For example, in Liberty Media Holdings versus Doe's 1-38, Mesut Tarhan's declaration amalgamates copied paragraphs from the Perino and Achache declarations quoted above, with the company name changed from Gardelay. I am the vice president of Excubitor USA, a company incorporated in Nevada with its principal address in Las Vegas. Excubitor is a provider of online piracy services for the motion picture industry. Before my employment at Excubitor, I held various positions at companies that develop software technologies. I have approximately 10 years of experience related to digital media and computer technology. At Excubitor, I am the head of the department that carries out evidence collection and provides litigation support services. I work closely with our research team to create credible processes to scan for, detect, and document copyright infringement over the internet. Declarations in 2011 and 12 also came from a Matthias Schroeder-Padouet. Matthias claimed association with copyright defenders and copied Mesut Tarhan's amalgamated copied paragraphs from Mr. Perino and Mr. Achache. For example, Matthias claimed in 420 Media versus Swarm, I am the vice president of Copyright Defenders, a company incorporated in Nevada, a principal place of business in Las Vegas. Copyright Defenders is a provider of online anti-piracy services for the motion picture industry. Before my employment with Copyright Defenders, I held various positions. So you can see that these are basically the identical paragraphs. At Copyright Defenders, I am the head of the department that carries out evidence collection and provides litigation support services. William Gorfine, Darren M. Griffin, and Daniel Maychek at Crystal Bay Corporation. Please note that Darren M. Griffin is in quotation marks. By summer of 2012, Crystal Bay Corporation became the entity most cited by declarants in non-pornography BitTorrent cases using amalgamated copies of the Perino and Achache declaration language. Mr. Lowe's filing history does not align with his declaration about Crystal Bay Corporation. Mr. Lowe makes representations about Crystal Bay Corporation that are objectively false as the ECF record proves. Mr. Lowe's declaration includes 2 paragraphs about Crystal Bay Corporation and Darren M. Griffin. He declares, "I understand that Mr. Griffin is an individual who worked briefly for Crystal Bay Corporation from 2012 to 2013 to verify infringement detection data licensed from Excipio. As explained in the supplemental declaration of Ben Perino, Excipio is a company to which parts of the Gardelay infringement detection system were outsourced in the 2012 to 2015 time period, and which in turn licensed the technology to others believed to have included Crystal Bay. I have no personal knowledge about Crystal Bay and have never worked with that entity. The only information I can glean from that entity is obtained from the South Dakota Secretary of State website, which he attached as Exhibit A, which indicates that the entity was formed in March of 2012 and ceased existence in or around March of 2015. Mr. Griffin apparently verified infringement detection data and submitted a number of declarations in various jurisdictions confirming the data, similar to what has been done in these cases by Mr. Arheit. But I have never met or worked with Mr. Griffin, and to the best of my knowledge and investigation have never submitted a declaration from him in any case in this jurisdiction. But there must be personal knowledge of Crystal Bay Corporation because Mr. Lowe's law firm filed declarations of declarants claiming a connection to Crystal Bay Corporation in at least 3 sets of cases: Dallas Buyers Club, Elfman, and Canal Street Films. Attorney Lowe filed 13 cases for Dallas Buyers Club in this district between July of 2014 and April of 2015. Each Dallas Buyers Club case commences with a motion to allow subpoenas supported by a declaration by Daniel Maychek, claiming, "I have been retained as a software consultant by Crystal Bay Corporation, a company incorporated in South Dakota and organized under existing laws of the United States." And he cites to 13 different declarations, it appears. Each declaration of Daniel Maychek is identical, 21 paragraphs. Each uses a copy of Mr. Perino's vast collection paragraph. Each is identical to the currently used declarations of Mr. Arheit in this district, other than substitution of Maverick I for Crystal Bay Corporation, including the typographical error of proprietary. Each declaration claims, 1, that the witness used Crystal Bay Corporation software, the forensic technology used by Crystal Bay is proprietary, software that collects, identifies, and records the IP addresses used by those people, and 2, that Crystal Bay determined that the defendants identified in Exhibit C to the complaint were using the ISPs listed in the exhibit to gain access to the internet and distribute and make available for distribution and copying plaintiff's copyrighted motion picture. Mr. Maychek does not state that he is a German national or that the investigation he allegedly undertook apparently was undertaken from Germany. The only geographic reference is to South Dakota. There is no explanation how a South Dakota corporation could lawfully employ a German national in its technical department. Each Dallas Buyers Club case includes a motion invoking work purportedly undertaken at Crystal Bay Corporation. Plaintiff has engaged Crystal Bay Corporation, a provider of online anti-piracy services for the motion picture industry, to monitor this infringing activity. Dallas Buyers Club also moved for default judgment on the basis of work purportedly undertaken at Crystal Bay Corporation. This motion for default judgment used declarations of Michael Patzer and Daniel Maychek. Mr. Patzer claims to be an independent contractor to Excipio of Germany with knowledge of Excipio's business. Mr. Patzer claims Excipio contracts with Crystal Bay Corporation to provide Crystal Bay with this data collection system, which is the system that Crystal Bay uses to detect infringement of plaintiff's works. Mr. Maychek's second declaration is identical to the 21-paragraph declaration initially filed with each case. The second declaration adds paragraph 22, claiming evidence of other infringements, and adds paragraph 23, an oddly worded disclaimer, "No one, including myself, has an ownership interest in Crystal Bay or vice versa." Mr. Lowe filed Maychek at Crystal Bay Corporation declarations in Dallas Buyers Club cases in this district between July 2014 and April 2015. Mr. Maychek claimed to work for Maverick during the same time frame where he was telling U.S. District Courts that his Dallas Buyer Club investigations were for Crystal Bay Corporation of South Dakota and its technical department. From my observation of BitTorrent, it is international by nature, and the investigations could not be anything but international at the stage of harvesting the data. Attorney Lowe represented Elfman in 2 cases. Mr. Lowe's appearance followed the withdrawal of Elfman's attorney Maureen Vandermeer for ethical reasons. Her motion explained, "Issues have arisen between plaintiffs' representatives and counsel, the nature of which make it impossible for counsel counsel to both continue with representation and comply with the governing rules of professional conduct. Mr. Lowe moved for default judgment in one case. The motion used declarations of Michael Patzer and Daniel Maychek, both claiming a relationship to Crystal Bay Corporation of South Dakota in their technical department. Judge Thomas O. Rice granted the motions. In another case, Mr. Lowe moved to dismiss the amended complaint against Mr. Lynch's client with prejudice. In opposition to a defense motion for attorney's fees, Mr. Lowe used declarations of Mr. Maychek and Mr. Patzer, both claiming a relationship to Crystal Bay Corporation of South Dakota in its technical department. Crystal Bay Corporation. Explanation provided under court order. Judge Rice ordered Ms. Vandermeer to provide a narrative of the relationship of Mr. Maychek and Crystal Bay Corporation to Elfman LLC. Judge Rice unsealed the document in 2018. The narrative includes APMC Inc. in the role previously claimed by Gardelais or U.S. Copyright Group in the Perino and Achache declarations. The company hired by the rights holder or the rights holder's sales agent, who in turn hired the investigator company, who in turn hired the declarant, who used software of a third party to conduct an investigation. Ms. Vandermeer writes in response to the judge's order, pursuant to this arrangement, Vision Films retained APMC Inc. to arrange for anti-piracy services for various rights holders, including Elfman LLC. Transmitted herewith is a copy of an agreement between Vision Films and APMC, which was executed in April of 2012. As you will see, Schedule A to this agreement lists titles other than Elfman. I am awaiting further confirmation on this point, but it is my understanding that the September 2012 Schedule A was intended as a substitute for the Schedule A to the April 2012 agreement, and that no new agreement was executed in conjunction with the revised Schedule A. As I understand it, the parties to the April 2012 agreement have abandoned the financial terms of their arrangement with respect to Elfman in various jurisdictions, including but not limited to the state of Washington. The April 2012 agreement was provided to me with certain terms redacted from Schedule B. In light of the parties' agreement to abandon this arrangement with respect to anti-piracy in this jurisdiction, I do not believe that this is an issue of consequence. APMC, acting on behalf of Vision Films and Elfman, retained Crystal Bay to conduct the subject investigation. As I previously explained, there is no agreement which memorializes this arrangement with Crystal Bay Inc. No financial terms were agreed to in connection with this investigation because this was considered to be a test case. The investigators were directed to capture IP addresses and record network traffic between the infringer's computer and the source computer. With respect to Mr. Patzer and Maychek, Mr. Patzer is an outside consultant who acted as the network architect and who designed the system employed by Crystal Bay to conduct the subject investigation. Mr. Patzer is responsible for ongoing maintenance of the network infrastructure. Mr. Maychek was working for Crystal Bay Inc. in conducting the subject investigation. Attorney Lynch continues that Mr. Lowe was aware of this explanation as counsel to Elfman, and because I raised it with him during the case. Mr. Lowe's law firm filed 2 cases for Canal Street Films. One case was assigned to Judge Edward Shea, the other was assigned to Judge Robert Lasnik, along with 48 other BitTorrent cases. Mr. Lowe used declarations of William Gorfien in these Canal Street Films cases. Mr. Gorfien's declarations used copied paragraphs from Mr. Perino and Mr. Achache, but Mr. Gorfien claims to work for IP Squared in its technical department. And you can see here it's the same language. I won't read it for the 4th or 5th time. But during this same time, Mr. Gorfien was filing declarations claiming a relationship with Crystal Bay Corporation. And then this paragraph is also similar and amalgamated like the others. In typed charts, alleged infringement is claimed in observations by William Gorfien from September of 2012 to December of 2012 while purportedly working for IP Squared. This time period overlaps with the time period of July 2012 to September 2012, which is the time frame of observations allegedly made by Mr. Gorfien while purportedly working for Crystal Bay Corporation. There is also a direct connection between Mr. Gorfien and Darren M. Griffin in this district. R&D Film filed declarations of both William Gorfien and Darren M. Griffin in the Northern District of Illinois. For example, in one case, William Gorfien claimed to work for Crystal Bay Corporation, while in another case, Darren M. Griffin claims to work for Crystal Bay Corporation. That same R&D Film filed 8 cases in the Western District of Washington, including the declarations of Darren M. Griffin claiming to work for Crystal Bay Corporation. In Canal Street Films, both judges asked for supplemental declarations. In both cases, Mr. Lowe filed second declarations of Mr. Gorfien. The signature of Mr. Gorfien in each of the second documents is obviously different than the original signatures used to start those cases. Plus, each new William Gorfien signature also appears to be a photocopy of the other, as does each old William Gorfien signature. It appears that many of the declarations of William Gorfien, whether working for IP Squared or Crystal Bay Corporation, includes photocopied signatures, including those filed in this district. And you can see here the signatures on the left all appear to be the same person. At least the handwriting seems to be the same, but they're just too close. They almost do seem like they are exact copies of one another, which by itself isn't anything to worry about. But then when you look over here and see this other one is a completely different signature. I mean, a completely different writing style. That's a different person there. Those are two different people, in my opinion. Mr. Lowe's representations about Darren M. Griffin do not align with the apparent facts. Mr. Lowe makes representations about Darren M. Griffin that are almost certainly untrue, as the record will show. Mr. Lowe's declaration includes 2 paragraphs about Crystal Bay Corporation and Darren M. Griffin. I understand that Mr. Griffin is an individual who worked briefly for Crystal Bay Corporation in 2012-2013. I have no personal knowledge about Crystal Bay, never worked with that entity. Mr. Griffin apparently verified infringement detection data and submitted a number of declarations in various jurisdictions, but I have never worked with him. In another case, Mr. Lowe confirmed Darren M. Griffin exists. Though much is to be made of Darren Griffin, a former investigator for Crystal Bay Corporation, there is no Darren Griffin in this case. To the best of plaintiff's knowledge, this former investigator has never been before this court or relied on any party in this district. Mr. Lowe also claimed there is no evidence that Griffin is a fake person or that Crystal Bay is a fake company. There is only Attorney Lynch's wild speculation, and plaintiff has no obligation to respond to wild and purely inflammatory allegations. Mr. Lowe claimed that Attorney Lynch has no evidence that Griffin is not a real person, that worked for duly incorporated Crystal Bay Corporation, or that he then ceased his work for the company. Mr. Lynch has no basis for any testimony regarding Crystal Bay Corporation, or that Mr. Maychek, who did testify in this case as a consultant for Crystal Bay Corporation, does not also provide consulting for other entities such as Maverick Eye. Mr. Lynch also claimed that Exhibit A to the Lynch declarations consists entirely of declarations of Darren M. Griffin, a former investigator for BitTorrent plaintiffs in other cases from other jurisdictions. There is nothing to tie these declarations to this case, though much is made of Darren Griffin, a former investigator for Crystal Bay Corporation. There is no Darren Griffin in this case. Mr. Lowe incorrectly claims that no declarations of Darren Griffin have been filed in this district. Scores have. Mr. Lowe made similar representations intimating the existence of Darren M. Griffin in the case Criminal Production v. Doe's. A pro se defendant brought a motion to dismiss citing Darren M. Griffin and his direct connection to Mr. Arheit. In opposition, Mr. Lowe represented, likewise, references to Darren Griffin or Crystal Bay Corporation are irrelevant. To the best of plaintiff's knowledge, the former is a former investigator for the latter, but which has never been before this court or relied on by any party in this district. But declarations of Darren M. Griffin claiming to have a degree in computer science, retained as a software consultant by Crystal Bay Corporation in its technical department, have been filed in 41 cases in this district. Declarations of Darren M. Griffin were filed in the Western District of Washington by R&D Film, 8 cases, Flypaper Distribution, 1 case, Private Lenders Group, 1 case, D3 Productions, 1 case, Writing Films, 7 cases, Zambezia Film, 12 cases, Ledge Distribution, 3 cases, and Voltage Pictures, 8 cases. Each declaration of Darren M. Griffin filed in the Western District is executed with only the initials DG. Each declaration cited here by me of Darren M. Griffin from the other districts is also executed with the initials DG. Each declaration of Darren M. Griffin that I have seen, but which are not cited here, are also executed only with the initials DG. As I have explained in Elfman v. Lamberson, an Eastern District of Washington case, after thorough investigation, I have concluded that Darren M. Griffin is likely fictitious. There is no such person. There is no technical department at Crystal Bay Corporation. 110 East Center Street, Suite 2053 in Madison, South Dakota is a mailbox center. Mr. Gorfine did not work there or for it. Mr. Maychek did not work there or for it. Darren M. Griffin certainly did not work there or for it. Venice PI's submission in response to the present order to show cause confirms my certitude that Darren M. Griffin is fictitious. Declarants Perino and Arheit claim to have met Pfizer and Patzer and Maychek. No one claims to have met or spoken with Daniel Susak, yet his identification was produced for counsel. No one claims to have met or spoken with Darren M. Griffin, and his identification has not been seen. No employment records, no tax records, no payment records, no immigration records, no address, no family records, no computer science classmates, no photographs, no correspondence, no voicemails, no emails. Crystal Bay Corporation is not explained, other than Docket 38-1, a printout from the South Dakota Secretary of State showing its incorporation from 2012. Note that page 7 shows the president as Peter Kurtz with an address of 110 East Center Street, Suite 2053, Madison, South Dakota. I am suspicious that Peter Kurtz is likewise fictitious and in any event not the president of Crystal Bay Corporation, but that is not the subject of this declaration. There was an attorney Nicholas Kurtz, who was a defendant along with Gardelay in the Shikarov case. And referring to this Exhibit 38-1, here is the South Dakota Secretary of State printout showing Crystal Bay Corporation existing at this address, 110 East Center Street, Suite 2053, Madison, South Dakota. I bet you if somebody typed that into Google, we could see a street view of what exactly this technical company consists of. If there were ever a time for a presentation of identification and a declaration of Darren M. Griffin, it would have been in response to the order to show cause in this case, but that did not happen. An explanation was provided, but the explanation cannot be true. Darren M. Griffin, with a degree in computer science, who was retained as a software consultant by Crystal Bay Corporation of South Dakota in its technical department, does not exist. Darren M. Griffin filed over 500 declarations in United States district courts, including over 50 declarations filed in this district, all claiming to be employed by or a consultant to Crystal Bay Corporation. I have logged the plaintiff's district case numbers and filing of as many Darren M. Griffin declarations as I could locate using my Pacer search techniques, which do not allow searches by named declarant. I can provide this data to the court if requested. 49 BitTorrent lawsuits were filed in this district between 2012 and 2013. All were assigned to Judge Lasnik. Mr. Lowe filed one of these cases, Canal Street Films v. Doe's, discussed above. Seattle attorney Richard Sims filed 48 cases identified above. Salem attorney Maureen Vandermeer filed 2 cases, Elfman and Thompson Film. All 3 counsel moved for orders allowing subpoenas. Ms. Vandermeer used no declarations with her requests. Mr. Lowe used the declaration of William Gorfine. Mr. Sims did not submit a declaration in a few of his 46 cases, but the majority of them include a filed declaration of Darren M. Griffin. For example, in R&D Film 1, the declaration reads, "My name is Darren M. Griffin. I am over 18, otherwise competent to make this declaration. It is based on my personal knowledge, and if called upon to do so, I will testify that the facts stated herein are true and accurate. I am, a typo, a software consultant with 9 years experience working in the field. I have a degree in computer science." This is a variation of the Achache 10 years experience paragraph above. The Western District declarations of Darren M. Griffin also use Mr. Perino's vast connection paragraph. After granting subpoenas in each case, Judge Lasnik, on his own, issued an order in May 2013 terminating all subpoenas in all cases. Each of the 3 counsel were required to respond to an order to show cause regarding Judge Lasnik's concerns about litigation abuse. Ms. Vandermeer submitted a response that is under seal. Mr. Lowe submitted a second declaration of William Gorfien, as described above, with the new signature. Mr. Sims filed a second declaration of Darren M. Griffin in all of his cases. Darren M. Griffin declarations in other districts. Darren M. Griffin signed declarations by initials DG in every district. In most districts, Darren M. Griffin claimed to be retained as a software consultant to Crystal Bay Corporation, but that differs in some districts. In Bait Productions v. Doe, in the Middle District of Florida, Darren M. Griffin uses the credible processes paragraph, the 10 years experience paragraph, and adds I work for Crystal Bay Corporation. In Killer Joe Nevada versus Does 1-18 in the District of Delaware, Darren M. Griffin uses the vast collection paragraph and claims I am a data supply expert with the firm Crystal Bay Corporation located in Madison, South Dakota. Also, there are other districts in addition to Western District, Washington, where a second declaration of Darren M. Griffin was used in response to a judicial order for more information. The use of a fictitious declarant, Darren M. Griffin, is directly connected and related to the other declarants used in the non-pornography cases, Mr. Perino, Mr. Achache, Mr. Gorfien, Mr. Machek, and Mr. Arheit. Darren M. Griffin is connected to each of the non-pornography declarants. Fictitious declarant Darren M. Griffin is literally connected to the other declarants in Attorney Lowe's cases. It can be shown, 1, that the times of alleged observations by those declarants literally overlap among declarants and their purported employers, and 2, that the declaration language of Darren M. Griffin overlaps among declarants and their purported employers. The claimed observations overlap for each witness and company in this progression. Arheit at Maverick Eye observations overlap with observations claimed to have been made by Machek at Maverick Eye, which 2 overlap with observations claimed to have been made by Machek at Crystal Bay, which 3 overlap with observations claimed to have been made by Darren Griffin at Crystal Bay, which 4 overlap with observations made by William Gorfien at Crystal Bay. All of this can be seen from PACER records. To me, these overlaps show, 1, that declarants are not making observations, and 2, that data is not being collected by differing entities. For example, Mr. Arheit testified in this district in a criminal productions case that he made observations for Maverick Eye from June 25th to June 27th of 2016, but in another criminal productions case, Mr. Machek testifies that he made the observations from June 25th through June 28th of the same period. So those overlap, but note that Mr. Machek's declaration was signed June 14th, perhaps June 16th, before the alleged observations took place. I discovered 4 District of Colorado cases for criminal productions where a Machek at Maverick Eye case was filed where the declaration was signed before the claimed observations were made. In those 4 cases, the signatures all appear to be photocopies and all 4 predate the alleged observations. Here are the copies of the signatures. The first one covers dates from June 25th through 28th and is executed on what looks like the 16th or 14th day of June. It looks like a 6. The little squiggly line at the end is like the pen caught the paper and it didn't make the loop, but it's identical. Whether or not it's a 4 or a 6, there's no way that the first digit is not a 1. And these are 4 observations that are made from June 23rd, from June 1st, from June 4th, through dates that are past the 16th. So how could he be signing the declaration about the observations he's made when the date of signing is before the date of some of the observations that are in the declaration? That seems to indicate a copied signature. The copied declaration language also shows overlap between Darren M. Griffin and other non-pornography declarants, Mr. Perino, Achache, Arheit, Gorfien, and Machek. The declarants from 2012 to the present all used copied paragraphs from Mr. Perino's and or Mr. Achache's 2010 through 2012 declarations, including 1, the 10 years experience paragraph, 2, the credible techniques paragraph, and 3, the vast collections paragraph, among other commonalities. These overlaps occur regardless which investigator company the declarant claims a relationship. For example, each of the declarant investigator combinations used Mr. Perino's vast collection paragraph. William Gorfien for IP Squared, William Gorfien for Crystal Bay, Darren Griffin for Crystal Bay, Daniel Machek for Crystal Bay, Daniel Machek for Maverick Eye, and Daniel Arheit for Maverick Eye. Mr. Arheit's declaration is directly derived from Darren M. Griffin and other Gardelais declarants. charts. The current declaration of Mr. Arheit used in the Western District of Washington is nearly identical to declarations of Mr. Maychek used in the Western District of Washington for Maverick Eye and Crystal Bay, as cited in cases above. That original Maychek declaration from Dallas Buyers Club is literally an amalgamation of the declaration of William Gorfien filed in the Western District of Washington by Mr. Lowe and the declarations of Darren M. Griffin filed by Mr. Sims. Mr. Maychek's declaration in Dallas Buyers Club is nearly identical to Mr. Gorfien's declaration in Canal Street Films. Changes are seen in Mr. Maychek's paragraphs 5, 8, 9, 11, 14, 15, 16, and 19. Some are slight, some are entirely new. All 12 of the other paragraphs are identical or nearly identical to Mr. Gorfien's declaration, other than changed names, including Crystal Bay Corporation for IP squared. Comparing the Darren M. Griffin Western District of Washington case to Mr. Maychek's paragraphs 1 to 5 of Maychek are paragraphs 1 to 4 of Griffin, paragraphs 7 to 8 of Maychek are 8 to 9 of Griffin, 10 to 12 of Maychek are 13 to 15 of Griffin, and 13 of Maychek is 18 of Griffin. Paragraph 15 of Maychek is paragraph 24 of Griffin. The current Arheit is identical to this Dallas Buyers Club Maychek at Crystal Bay declaration, 21 paragraphs with the company names changed and the role changed from software consultant to consultant. The witnesses overlap in testimony and times of observations, but surprisingly, the format of the typed-up charts of alleged infringement submitted with each case do not. The typed-up charts of alleged infringement appear to vary by plaintiff's attorney, not by plaintiff, and not by witness or by investigative company. For example, the charts accompanying the Western District of Washington, Maychek at Crystal Bay, Dallas Buyers Club cases cited above all have a chart arranged in the same manner. This same chart format is used in the Western District of Washington, Maychek at Maverick Eye, Cobbler, Nevada cases. This same format is used in the Western District of Washington, Arheit at Maverick Eye, Venice PI cases. But other typed-up charts for those same plaintiffs using those same declarants are different in different districts. Use Dallas Buyers Club as an example. In Colorado, Dallas Buyers Club filed both Maychek at Crystal Bay and Maychek at Maverick Eye declarations, but the typed-up charts of alleged infringement accompanying both forms of those declarations differs from that filed in the Western District of Washington. Indeed, the typed-up charts of alleged infringement for Dallas Buyers Club differ in each district, even if the declarant remain the same. A logical conclusion from this is that the typed-up charts of alleged infringement filed in each case are not the direct output of the computer software that is referenced in each motion to obtain the subpoenas. Here are some of the Dallas Buyers Club jurisdictions: Wisconsin, California, Illinois, Colorado, Texas, Oregon, Ohio, Florida, and Washington. Conclusion: I am confident that Darren M. Griffin is fictitious. I am confident that Crystal Bay Corporation of South Dakota did not employ any investigators. I am confident that the declarations of Mr. Lowe, Perino, and Arheit are inconsistent with records of the United States District Court, as I detail here. I would be willing to provide more information to the court as may be requested. I declare under penalty of perjury of the laws of the United States that the foregoing is true. Executed this 23rd day of February 2018, J. Christopher Lynch, Lee and Hayes, Spokane, Washington. So there was a tremendous amount of technical stuff to follow in there. But if you were able to follow it, what I think was revealed to you was that a defense attorney in Washington state has noticed some inconsistencies in the file sharing cases that he defends. And in these cases, he has found that the expert witnesses who are testifying to the alleged file sharing that they investigated, these expert witnesses might not be who they say they are, and they might not be controlled by who they say they're controlled by. We've suspected for a long time that the investigating company in Germany was really pulling the strings behind a lot of these BitTorrent file sharing cases, and even yours truly has raised the argument in court that that company should not be authorized to investigate U.S. citizens without knowing more about them. Unfortunately, not every single judge always agrees, and you can see here that it's taken until 2018 that Mr. Lynch has been able to find the inconsistencies from 7 years ago. So This is really remarkable. This could undo a number of BitTorrent file sharing cases that were supported or are supported by declarations of these people, and especially the fictitious person, the allegedly fictitious person, Darren M. Griffin. If this turns out to be true, it will probably have pretty big waves in the copyright file sharing defense community. We will have some more ammo. In fact, this declaration itself should be something that defense attorneys like me are reviewing around the country for leverage to use in our cases. I hope you enjoyed that story. We are, of course, a community-supported channel. This channel is really only possible because I've been able to take time away from being a practicing attorney to spend time making these videos. And I really appreciate that. This has been a life-changing opportunity to be a creative professional, and I'm honestly very, very grateful for it. So thank you very much to my $50 plus Patreon supporters in the month of March. You are DJ Gilcrease, John Steele, Gavin Barnard, The Godslain, Evie, Andy, Kyle Mudrock, John H. Anderson, Verimentane, and Sean McNamara. There are also over 200 of you supporting at the $5 plus level. You're scrolling on the screen right now, and it absolutely blows me away how many of you there are. I have heard your requests for more tiers and more rewards and more community participation, and I want that too. And we're working on that. Our staff is congealing. We've been spending more and more time together. You've seen some of our Twitch streams playing video games together. Well, those team-building activities are more than just games. And I think you'll be seeing the results of our congealing sometime soon as we are able to put out more and better stories for you with actual human resources. So, a word that I hate. Humans are not resources. Humans are people. So thank you all for making this whole thing so very possible. I look forward to seeing you in my next video. Have a great week. I'm Leonard French, your favorite copyright attorney, and I'll see you next time.